Hey, estate planning attorney Paul Rabelais here, and in this video we're going to talk about a couple of things that some estate lawyers do when they write wills. A little bit misleading, borderline inappropriate, that helps those lawyers assure that they're going to be handling that probate legal work in the future. Okay, so most people are aware that in many cases that attorney involved and court involved probate proceeding when somebody dies, it's hard enough. But sometimes heirs are misled by the attorney who wrote the will. Let me give you a couple examples. So I will start by saying kind of lawyers, like, estate planning lawyers, they know that the real, money in writing wills is not necessarily in the writing of the will, but the real money is in the probate of the will when what's called the testator, the person who wrote the will, dies. Legal fees for probate typically far exceed the fees for writing the will. So some lawyers, when they write wills for their clients, they do a couple of things to ensure that that attorney who writes the will gets the probate business and the fees when that testator dies. All right, let me give you one of those examples. One is, quite frankly, when the lawyer keeps the original will. So the way it works, Jim is in the lawyer's office. Jim is signing his will and says, "Hey, Mr. and Mrs. Lawyer, what do I do with my will?" And the deal is, when Jim dies in the future, that original will that Jim is signing there that day has to be produced. If it's not produced, or it can't be produced, or it can't be located when Jim dies, it creates this presumption that Jim destroyed the will with the intent of revoking it. So the lawyer typically says, "Well, I'll tell you what, Jim, as a courtesy to our clients, we will store your original will. I'll keep the original so that when you die, your executor can just contact us and we'll have it." So really what their lawyer is saying when Jim says, "Mr. or Ms. Lawyer, what do I do with my will?" Really the lawyer is responding, "Tell you what, Jim, when you die, the first call that your executor is going to have to make is to me, because nothing can be done without the original will. And when they call me to get the original will, I'm going to make sure that I secure the lucrative probate work, because all the heirs got to come through me to get the original." So we see a lot of lawyers, not a lot, we see some lawyers keeping all of their clients' wills. To me, it just doesn't make sense. I'm a 55-year-old estate planning lawyer. Let's say next week I prepare a will for a gentleman who's 60 years old, and I keep the will. And let's say that gentleman dies when he's, let's call it 92. 32 years from now, I'll be 87. I'm not going to be working. I don't know what's going to happen to my business. It may dissolve when I retire. Maybe somebody takes it over and then somebody takes it over from them. But 32 years from now, when Jim dies, who in the heck is the family going to contact to try to get that original will, which they need to get? They may not be able to find it. Or if 20 years from now or 10 years from now, I retire with this safe full of thousands of wills, and I've got to go find all these people to give them their will back. How am I going to find Jim? He's probably moved 2 or 3 times since we had his address when he originally signed his will. So, it just doesn't make sense to me that lawyers should keep wills, because sometimes people sign wills and then they don't need to be produced again for decades, sometimes many decades later. Keep your will, let the appropriate people know of its existence and its whereabouts, and then allow your executor or your heirs to select the provider of those estate administration legal services when you die, without having to feel pressured into using the legal services of that lawyer who is holding the will hostage. All right, so that's one thing lawyers do. The other is also kind of sneaky, a little bit shady in my mind. It's when the lawyer appoints himself in the will as the attorney for the executor. So Jim is talking to the lawyer about getting his will done, and lawyer says, Jim, in your will, you need to name an executor. I'll prepare all of that for you. Who do you want your executor to be? And Jim says, you know what? I want my son Billy Bob to be my executor. Billy Bob's responsible. He knows my business. He'd be the executor. Lawyer says, great. I'll write up your will so that your son Billy Bob is the executor. So lawyer writes the will, and in the will it says, I appoint Billy Bob as my executor. And then the lawyer sneaks in a provision to the will which says, and let's call lawyer hotshot probate lawyer. Hotshot probate lawyer sneaks in a provision to the will that says, I not only name Billy Bob as my executor, but I designate hotshot probate lawyer to be the attorney for my executor. Now, I know that, I guess it was maybe 40 or 50 years ago, in my state, Louisiana, our Louisiana Supreme Court said that provision of a person in a will designating a lawyer as the attorney for the executor is non-binding. But neither Jim nor Billy Bob, read that court case from 40 or 50 years ago. So when Jim dies and Billy Bob reads the will and sees that Jim named hotshot probate lawyer as the lawyer for the executor, Billy Bob doesn't know any better. He feels like he's got to use hotshot probate lawyer as the lawyer to settle the estate. And so while I know it's not binding, the Billy Bobs of the world, they feel obligated. So really what the lawyer is saying when he inserts that provision in the will that says, I designate hotshot probate lawyer as the attorney for my executor, he's saying, I know that when the heirs read it, they're not going to know that provision is non-binding. So they're going to feel obligated to use my probate legal services, and then I can perhaps charge them excessive probate legal fees because they think they're locked into me. And so again, those are just a couple of things that lawyers do that borderline inappropriate. Lawyers know the business. They know the money is not in the writing of the will, but in the probating of the will. So when they write the will, they try to do some things that more secure, that more lucrative probate or succession, as we call it in Louisiana, legal work. So probate is hard, can be hard. It's not a disaster in every circumstance, but those in charge of completing the probate, executors, heirs, should be able to use the legal services of the attorney that they feel is most qualified to settle the estate. Lawyers keeping original wills and appointing or even recommending themselves as the attorney for the estate or the attorney for the executor, they're misleading the executor and the heirs into thinking that those executors and those heirs are stuck with one attorney and one attorney only. Now, I will say as a side note, if you want to, many people in America choose to, instead of writing wills, keeping everything in your name, requiring that court and attorney involved probate proceeding when you die, many people establish their, I'll call it revocable living trust, so that they create their trust, which really replaces the will. They transfer title of assets that they own into their trust while they are alive. So when they pass away, the successor trustee of their trust can step in and immediately disperse trust assets to the heirs, or in trust lingo, the beneficiaries of the trust. And all of that trust settlement can be done outside of the attorney and court involved probate process, because things in a trust just don't have to go through the same process that assets in your name have to go through when you pass away. So know that is an alternative. Okay, hope that helps. Make sure you smash the like button. If you haven't already subscribed, hit the subscribe button and the notification bell. That way you won't miss any of my future videos. and by doing me a favor and obliterating the gray like button, making it blue, you'll be telling YouTube, hey, show Paul's videos to more people, which is all we're trying to do here. Okay, I'm Paul Rabelais, estate planning attorney. Y'all have a good day.